Hello, everyone. Welcome back to the e-Discovery channel from beautiful downtown. Yeah, we got another hurricane coming in New Orleans, Louisiana. Doug's laughing because he's far enough over to the west of us in Houston that this one doesn't look like it's going to head that way. So, although it's still
We'll
four
see.
days away, yeah, anything can happen once it gets into the Gulf of Mexico. Predictions are nice, but uh, hurricanes are a different thing. Um, and we are really happy to have with us today Adam, and correct me if I get this wrong again, Adam Gutbezhal.
You got it.
All right. I've been practicing feverishly since you told me how to pronounce it.
I still get it wrong myself. Don't worry about it.
Adam's with a practitioner with the business law firm of Ruberto, Israel, and Weiner, or
Weiner.
Weiner. Okay. Uh, Located in downtown Boston, a hop, skip, and a jump from every bar I used to go to when I was a when I was a heavy drinker, or a light drinker, or a day drinker, or an afternoon drinker. There was, you know, if the Black Rose was closed, the Bell in Hand was open. If the Bell in Hand was open, JJ Donovan's was ready to go. There was always a bar open in Boston, and if there was nothing open downtown, I go to Southie to the Erie pub. They were always open. So those are.
They're still going strong, many of them.
Oh yeah, oh yeah, yeah. Um, so, anyways, but your firm is located right down there on the waterfront in Boston. So I'm jealous. Um, a lot of things have changed. Of course, the courthouse used to be over by Post Office Square. I understand there's a beautiful new federal courthouse down towards Southie,
Yeah, right
down
on
along.
the water. It is beautiful. State courthouse is still right by the concrete jungle that is the city hall. That's still alive and well, Superior Court, and the federal court, which is diagonally behind me, is a gorgeous place. So I have the joy and pleasure and honor of representing clients in both buildings from time to time.
Nice. So the state
Yeah,
Suffolk County Court is still up by the State House and down just above Government Center there.
that's
Yeah,
right.
Government Center, which used to be in my father's day, uh, uh, when he actually joined the Navy when the Japanese bombed Pearl Harbor, but he did shore patrol in Boston for about 9 months before they shipped him out, and that was, of course, Scully Square before it was the concrete jungle, and that was the basically the red light district of Boston. Although some would say the practitioners haven't changed much since then, just the buildings are different. But now it's that brand new weird kind of government building. Yeah. Uh, so, anyways, Adam, we want to talk about all things technology. Adam and I, for those of you who don't know, were two parts of a double header on a CLE recently where we talked about specifically about AI, but of course then talked about a lot of things technology centric, and and I thought it would be great to get the perspective of a practitioner, since we've been talking a lot to consultants and experts and people in big firms, and so now we've got a real live practitioner. So, Adam, tell us all about the many different ways you use AI in your practice.
So, first, thanks, Tom, Doug, and eDiscovery Channel for having me. It's a true honor to be here. And I do have to do, being a practitioner, I have to do that unfortunately necessary throat clearing, which, nothing I'm going to give you guys constitutes legal advice. And
Oh
I
yeah,
represent clients in AI space. And so I'm not providing their opinion. This is just my crazy
yep,
2 cents here. So,
yep,
that said, as you all know, and from many of the interviews you've conducted, AI and tech in the legal industry, it's sort of the wild, wild west right now. People don't really know what it is. I like to use sometimes a Supreme Court decision where they talk about pornography, and the saying is, you know it when you see it. Right now, tech, you know it when you see it, because people are still trying to figure out the space.
yeah.
Um,
I'm not sure that's even true of AI. I'm not sure you do know it when you see
Well,
it.
yeah, I mean, how you define AI in and of itself, right? People are talking about this like it's this brand new thing, but if I unlock my cell phone, I'm using facial recognition, that's AI, or if I get autocorrect, that's AI. We've been doing that for years. Instead, it's these LLMs, right? All of a sudden, because we have what come across as very intelligent chat bots. It's like, oh my gosh, computers can do all the work for us. It's like, well, they were doing it before, just you didn't see it. And also, they're not as smart as you think they are. So that's the fun that we're getting into. You get a lot of lawyers, we have, especially in the private sector, we have only so much time in the day. There's certain exigencies that we want to have, and you're trying to do as much as you can with as little time as possible. And so if you can outsource it to somebody else or to a computer, you will, but haste makes waste, right? You still have the same exact issues. Just because you think it's a computer and it comes across with a confident response doesn't mean the response is correct or well formed. And that's what we've been seeing. I can tell you my 2 cents. I personally do not use AI, and I'm going to define it, since again, nobody knows what AI means. I don't use large language models as part of my practice, right? I know colleagues in other firms who will use it sort of to help get ink on the page, right? To start a thought process, to prevent or stem writer's block. There might be some benefits to that, but I can tell you almost every jurisdiction in the US now has seen at least one lawyer get sanctioned or fined because they're submitting things to the court that are cases that are completely made up, right? Because these chatbots just make things up. They don't, rarely do you see a public facing open loop chatbot tell you, I don't know, right? They're like that confident uncle at your Thanksgiving who just seems to always have an answer for everything. And when you're like 10, you think that's amazing. And then you're 16, and you're like, oh my gosh, will he ever shut up? Like, how does he know? Or maybe when you're 26, like, how does he know? Like, how does Uncle Mike know everything about everything? And you realize, oh, he doesn't. He's just full of it.
He's just making it up. Yeah.
He's just making it up. Right.
So how about, well, so 2 questions come to mind, and we've had this discussion, but so the first is advising or discussing this with your colleagues.
Yeah.
Are other attorneys as interested as we think attorneys are in AI? Or is that a marketing myth?
I'm going to answer yes. It's both. So anecdotally, attorneys are very interested in AI, and it runs the gamut from computers are going to take our jobs, right? We're not going to need attorneys because of all these things computers can do, to, oh my gosh, look at how much more I can do and be more productive because of AI, right? And there's somewhere in the middle, which are the people that are, I'd say, fence sitters right now, trying to understand what exactly this technology is, how they can use it, and how they can use it safely. Now, you have the huge law firms that have the capital that they can create their own systems. These very, very big law firms have been for years, where they can create their own chatbots, they can create their own document management systems that are entirely in-house, and they're, I would say, closed loop, right? They're not data scraping the internet, they are data scraping their own internal systems. You have a bit more confidence there because you know what the data is, or presumably should be, that's informing the output.
And that was, sorry to interrupt, but that's always been, and Doug has heard me say this, beat this dead horse before. The cost of that process is something that it seems to me has made it, if not easy, manageable for large firms, but not so much for firms the size of your firm.
Correct.
It's just not economically feasible.
No, we're a firm of about 30 attorneys, right? And what I think we're seeing in the marketing, myth, as you said, is I've started to notice it, and I think this is what's really going to happen over the next 2 or 3 years, is rather than one large platform to provide to an entire firm, it's going to be specialized areas. So we'll say, hey, we can give you an AI system specific to employment law, or specific to real estate or contract review. And we're starting to see some of these. And say, therefore, you don't really have to worry about it giving you things that are completely irrelevant. We're using data only for this area of law. And because it's specialized, the price is just above what you would think is reasonable, but you're really going to.
But the second question is one which you just mentioned, second point.
Yeah.
The big firms can use their own data because they have so much of it. How comfortable, if this question has come up, are firms of your size with using a system that takes data off the internet, or conversely wants to put some of your data someplace on the web where it may be used.
So
Does that discussion come up?
oh yes, absolutely. I mean, it's a discussion I have with my clients about bear in mind, uh, you don't know if you don't understand how the system works, how are you ensuring that the information being used to feed it is correct or is accurate? You just need to look at what happened with Google's AI. You know, when they first tried to launch it as the initial search, it was telling people that were looking for dietary advice to eat a rock a day, or if they wanted to prevent their cheese from sliding off of their pizza, to put some glue on it because it would help the cheese stay there. These are things that
Hey,
were online. Now, I'm not gonna, you know, if you want to eat cheese pizza with glue, to
hey,
each
I
their
ate
own.
Elmer's glue when I was a kid. It was all right. Who didn't
And
eat
look,
paste? Who didn't eat paste when they were kids, right?
right, but now do you want an AI system that's telling you comfortably that's what you should be doing? And I like to use these examples because they're to us they seem so ridiculous, right? But if it's a topic you don't know a lot about, right? If I love to use the rule against perpetuities, right? This thing in trust and estates that I had to learn in law school and for the bar, and I hope I never have to experience again. But if all of a sudden I'm looking for a refresher because it's coming up in a case, if I don't really know with certainty what's correct or not, and I use this and it gives me wrong information, I'm probably not going to know that it's wrong. And that's how lawyers are getting pinged. They're copying and pasting false case sites.
And that brings up the second area that I wanted to talk about, which is specifically litigation.
Yeah.
Are you have you been involved in any litigation where you're getting discovery, where if not you, the other side has used AI? Do you know if they've used AI? Um, we've kind of gone from litigation support systems to TAR to AI, and made this like quantum leap. Um, that
Yeah, because Tom, when you say used AI, we have to define what that means, because
Yeah,
we've been using AI in litigation for 15 years because we've been doing TAR and all sorts of machine learning and what have you. So as the question really, are you aware of opponents using, I guess, generative AI and
yeah.
large language models? Have you seen any of that?
I have not experienced that yet. And I emphasis on yet, in part because I don't think it's become as prevalent. And bear in mind, what I foresee is OpenAI getting a number of subpoenas because, or Grok, you know, some of these Microsoft, other entities would get subpoenas with respect to somebody's use of those systems, because you have to be a company of a certain caliber to have your own internal large language model or your own sort of AI-based document management system that we would know, hey, they were using this. Now, as part of the discovery process, you should be providing that to us. Often it's going to be what happens like when people use Google Docs, Google Sheets, Google Vault, you know, these things that become these impenetrable things that increase the costs of discovery because Google is very protective of that information, in part because they want people to continue using it and feel like it's safe, right? So it needs to be a subpoena to Google. It has to use very particular language. Otherwise, they just make it cost prohibitive for a party to continue to try and litigate with Google as a third party to get some of those materials, right? I've had situations where clients or the opposing party uses the Google platform to store their documents, and I would always advise somebody to stop doing that, right? Because you can't guarantee security in some ways that you can with when it's internal, right? You get a rogue employee or former employee, they can just deny access to everybody if it's a shared folder, for example, right? It's hard to assert you have some sort of proprietary right to things that are being housed on a Google platform, right? Unless you have a license. So that's why Microsoft, if you have things with Microsoft, you can argue that it's proprietary because you hold a license with Microsoft. You might not have the same license, or it might not be perceived the same way with some of these cloud-based platforms. That's where
unless
it can get
unless you're a Teams channel and you give access to an outsider
right,
to be part of that, that's a real problem we're having
right,
now. Is, oh yeah, you're licensed. Well, my client isn't really part of the license. We just granted him
right. We
the
share
right to come in
exactly.
and join the chat. So
You
to
do
join,
these share
go on
folders
in and join the chat.
or, you know, Slack history, trying to get the Slack conversations from people. So
Yeah.
we see that, and no surprise, people are very resistant to hand that over. I think sometimes in part because they don't realize how often they're using it, and therefore it's something that is discoverable. They also may not understand how they produce that. And then we get the ESI vendors in, and that can make things very expensive, right? It's that sort of unfortunate part of litigation is the cost benefit analysis of what are we talking about in damages with respect to this case, and does it justify bringing in a third-party ESI vendor?
And so related to all of this, Doug just touched on it, is we've spent a lot of time in our space, the know-it-all consultant space, over the last couple of months, talking about hyperlink attachments. And, you know, big thing that touches on the issue you just talked about. You know, Google Vault is fairly impenetrable. They don't take a corporate attitude of we're going to worry about that. Microsoft is trying to accommodate that, and I think rapidly just realizing it's causing them more headaches than they thought it would at the onset. But is that something litigators in your arena talk about? I mean, are the guys sitting around the coffee shop and, you know, in Government Square on a Tuesday morning and saying, "Hey, did you read that new hyperlink attachment decision?"
Right. Well, and I'm also interested because, you know, whether your clients are using these things or not, I'm sure many of your opponents are using them. So I'm wondering about your perspective from that standpoint. A lot of the big companies are using, many are using Microsoft, some are using Google. And so you have to be concerned about how you get to those files, right? So I'd be interested in that perspective as well.
So are people talking about it? I joke that if you ever want space at a dinner party, come stand next to me, and I can start talking about AI and e-discovery, and I can clear you a lot of elbow room. No, it's not being discussed. I honestly, I think even just ESI at the state level, I should clarify, at the state level in particular areas of law, ESI is just becoming part of the norm, right? The expectation that ESI searches will be conducted for communications. Now, it also varies on the area of law, right? Construction disputes, for example, there may not be a lot of email traffic. It's often going to be, you know, contracts and things of that nature. But when we're getting more into the corporate dispute matter or employment law, especially, that's where it's becoming the expectation. Because employment, and Doug, to your point, you have to know what they're using or have an idea of what they're using. And often in an employee-employer dispute, the employee knows because they were using it, right? So they can inform the attorneys of this is how we were communicating. This is how we were obtaining documents. We were providing them out to, you know, vendors or clients, what have you. Then you can make more targeted requests. But there is, you know, you have to understand the systems in order to be able to ask the right questions.
Right.
And I'm sure to you, it's not surprising that technology and attorneys don't always mesh very well, right?
What? I'm shocked. I'm shocked. I thought
almost never. Well, or I don't know about almost never, but very often they don't. So
my understanding of technology comes from my dad forcing me to watch, you know, Terminator and 2001: Space Odyssey as a child. You know, and there's no class. I know somebody who had recently graduated from a Boston-based law school, and she had a course that was specific on e-discovery.
Really?
I graduated, you know, 11 years ago.
Suffolk Law School, right? Suffolk Law School, not BC Law.
Correct. Suffolk Law School has a course on e-discovery, but you know,
it's unfortunate that we can name the 6 schools that have those courses.
Right. And it should be, you know, if you are doing civil procedure that, you know, first year of law school, then second or third year of law school, there really should be a course on the discovery process and this type of technology.
Yeah. So that raises an interesting question. I mean, but the fact that attorneys are trying to avoid it still, I mean, I vividly remember back, you know, in the early days of e-discovery, like 9 years ago, when all this stuff was first starting. But Judge Peck told a story about a case that had appeared on his docket, and it was, I forget, like maybe a patent case or something with some technology in it, but he thought it was going to be really ripe for e-discovery, and he was kind of chomping at the bit, like, great, these guys are going to be, filing motions and yada yada yada. And he brings them in for a conference, and they're going over the list of stuff, and then he gets to e-discovery. He says, "So, okay, plaintiffs, what do you got for me? We got, you need a day to talk about e-discovery arguments. No, Your Honor, we don't have anything." And he thinks, "Oh, that's kind of weird." And he looks at the defense. "Well, how about you? You got anything?" And they say, "No, Your Honor, we don't have anything." And he looks at them, and they're both kind of like looking off into the sky. He goes, "You bastards decided with each other not to ask about ESI, didn't you? You've already agreed not to even open that can of worms." And they just kind of went, "Well, maybe."
Yeah.
And so, yeah, it's interesting that we're probably still at that level. I mean, I think of Boston, I'm thinking, well, those are going to be pretty technology savvy attorneys in Boston, right? And then you're saying, well, there's one law school that offers a course, and the state level cases, people are still avoiding it. How about collection of data, like self collection off cell phones? That's become a big deal. Are you seeing much of that?
That is one of the things that there's the greatest resistance about, especially I would say in my experience with text messages. So this is, I wouldn't say that people are intentionally avoiding it. Unfortunately, litigation is expensive. And when it comes to this sort of data collection, I would say it is the norm when we are talking about these multi-million-dollar cases.
Sure,
right?
sure.
Right. But when we're, unfortunately, even when we're talking about a case that the damages might be in the mid six figures, it's a serious calculation. You have to determine whether you want to go down this e-discovery road, because you have to get outside vendors involved, right? You have to perform the review, right? If you're being requested to provide ESI, well, then you have to have somebody like me that's reviewing it for privilege, right? Or work product. I have to make sure that there's not the inadvertent disclosure, because certain search terms could come up with an attorney's communications, right? Or prior counsel. So you need to know who are your prior attorneys. It takes a long time to review all of that. And then also when it's produced to you, it takes a long time to review, because a lot of the stuff can be entirely irrelevant, right? As much as you try to target specific things, if the search terms hit, it comes up. I can't tell you the number of Twitter, emails I've received, or New York Times digests that I've had to review, because even though we do tailored terms, they come up. And then the same for cell phones. Often people don't realize those are discoverable. And
So
attorneys,
that's interesting to hear. So what I think I'm hearing you say is it's not, at least it's not as much as, or certainly equivalent to, technical resistance as it is the high cost of e-discovery,
which is financial.
So what's the alternative? I mean, because there is electronic evidence out there.
Sure.
I mean, there are platforms that are supposed to be like do it yourself, load your own data, let the attorney get right after review and what have you. Why are those not an option or a viable option?
Yeah, I think they are an option. I think there's, what is this, the old Chinese adage that the best day to plant a tree is yesterday, the next best day is today. Sometimes advising a client, hey, this is how you should be storing your data, or what is your procedure with respect to your data privacy? Are you deleting emails as a routine every year, right? As long as it's being done as a routine basis, that's fine, right? How are you storing things? We have some clients where for project by project basis, everything is automatically stored in a particular folder on their server. So it's very easy when it comes to e-discovery. They can just pull that folder, provide it, no questions asked. Others, you get companies who are small businesses, mid-sized businesses, they're growing. They don't realize that these are things that could be an issue. It doesn't occur to them that they might have to keep all these communications, because bear in mind, when people go into business with each other, they're not thinking of litigation, right? You enter into a contract with somebody because you think everything's going to work out fine, and it'll be sunshine and roses, and we'll all get along. And then, and oftentimes that's the case, but when it's not, people like me show up, And then we're asking,
Right.
okay, I want the text messages, I want the emails, I want the phone log records. And they go, well, I don't have that. Or the key phrase, unduly burdensome, right? You
Right.
need to go get a court order because it's going to take me so much time and cost me so much money to get those things. That's the cost benefit analysis. And Doug, sometimes the alternative is settlement.
Mm.
It'll
Oh,
cost,
sure.
you know, this much to try it, or we can compromise a bit and resolve this case.
Right. Well, yeah, and that's why, I mean, so many people are trying to push kind of discovery closer to where the data is, so they can at least assess what those costs are going to be, so they can make those settlement or litigation determinations. But that involves technology as well in some
Absolutely.
cases. So,
Well,
yeah.
and to bring it full circle, one of the things that AI, I think, is very appealing would be in that document review aspect, right? That's where that concern of, you know, AI is going to take our jobs is if I get 100,000 pages of documents, and if I can put it in a system that I say, here's what I'm looking for, you know, this is the context for which this was produced, synthesize this and provide me with the pages for the, you know, pertinent things. And instead of it taking 2 weeks, like it might take an attorney, it takes 2 minutes, you know, 20 minutes. That's compelling.
Sure. But since you talked about all the concerns about AI before and the fact that Google was telling people to eat rocks and stuff like that, what do you advise? I mean, you know, in that scenario where document review and relevance determination is a very important part of that process, what do you do to make sure that the AI is correctly evaluating those documents and giving you the ones that are truly responsive to the issues in the case?
Right. And the key component there is, and I don't mean to bemoan any of my fellow attorneys or myself to say that we're garbage, but garbage in, garbage out. If you are not providing the right prompt, you are not going to get the right answer. And sometimes when you're reviewing a human, you're reviewing a document, you're looking for multiple things simultaneously. And it may be that you're able to spell that out for an AI system. You know, look for these different components. And it could do that. I can tell you sometimes I'm reviewing documents and I see a narrative that I didn't know existed in the case until I'm actually reviewing the documents.
Sure,
Yeah.
happily happens
The
all the time.
whole,
Right?
yeah,
And
that
an
whole
AI
issue
system
of
isn't
prompt.
going- right.
Yeah,
Yeah,
prompting.
it's the prompt and output issue. And I like to use, because it's been prevalent in the news right now with Rupert Murdoch and his lawsuit in Nevada about his irrevocable trust. He has high-powered attorneys that are trying to demonstrate that language within that trust made it revocable.
Revocable.
Not
Yeah.
really, truly irrevocable trust. If you're asking an AI system to look at established case law and try and come up with that creative argument, well, this is a matter of first impression in many ways. It's not going to be able to do that. It's based off of past issues. It's going to look at documents based off of the current understanding of the law. That's where the human in the legal profession comes in. We're the ones who are expected to take an unfortunate situation for our clients and come up with a unique argument that shows why their situation is different. If the law is against your side, you argue the facts. And you should be.
I have a friend who's pretty tech savvy, and he's in Seattle, a lawyer.
Yeah.
And he sent me this email the other day. He said, so last night I was making dinner for my 5-year-old. I got the laptop in the kitchen. And so I asked Copilot, hey, what should I make for my son for dinner? He likes fried chicken, chow mein. I'm reading this, of course. Yakisoba, he's Japanese. Yakisoba, pizza, and hamburgers. The suggestion, make him fried chicken, chow mein, yakisoba, pizza, or hamburgers. He forgot to add, what should I make him other than these 5 things that he
Right.
likes? It was all the question of what we like to fancy up and call prompt engineering, but asking the right question the right way. But that's what we get paid for, right? That's what you get paid for, Adam. Right? That's what you've always been paid for before computers. When somebody used to come in and throw 20 boxes of paper on your desk and say, hey, I got a problem. Here you go. Figure it out.
There's no question that technology makes things better, right? It used to be if you were looking for case law, you had to go to the key site in the actual, you know, this thing that we used to call a book, where things were printed, and then you have to go to the wall and find the right book that had the case and look at it that way. Whereas now you have
And shepherdize it. You had to shepherdize it,
correct,
right?
and,
Then you had to
and
go to the little red
navigate
books.
through books, right?
Yeah.
Whereas now you have, Bloomberg Law, Lexis, Westlaw, you name it, that you just put in the right Boolean search terms, or now you don't even need Boolean, right? It's now more like a Google search, and it's all right there for you. That's fantastic. That's a lot faster. But I wouldn't ask one of those platforms to just do the work for me, right? I remember one of your interviews you did a couple of weeks ago. I think we were talking about Copilot. You can get some of the output. It's serviceable, but this is where some attorneys think serviceable is good enough.
Close enough.
They
Yeah.
use that.
Right.
So the question in my mind is, like, you just, again, not to beat the dead horse, but I will. So we have so few law schools teaching this. Where do you go to learn this? Where do you go to get this information? Where do you get to break this log jam of, oh, it's too technical and I don't understand it? Or do we?
Well, some of it is on the job experiential learning, right? Having a case that involves it, and hopefully having a good team. I'm very fortunate at RIW. We collaborate a lot. We are truly a team here. And so we ensure that we have at least 2 attorneys on a case. So we're giving adequate representation, and really more than adequate. We bounce ideas off of each other, and there's no dumb question, right? I think if you have that type of practice, you really should be able to rely on each other. And if you don't,
So you do sit around at the coffee shop talking about hyperlink attachments.
Well, that's usually how I'm able to clear the room if I talk about that. And that's where they kind of rely on me, right?
You know what I mean? You know what I mean? In every courthouse in America that I've ever been around, across the street, within a half a block, there's a coffee shop where attorneys and sometimes judges, especially at the state court level, are coming in and having a cup of coffee at 7 o'clock in the morning, 7:30 in the morning, and talking about stuff. It's like we don't have the electronic coffee house.
Well,
You know?
some of that's been lost because of so many court appearances being on Zoom now, right? You're not really seeing people in the hallway. And don't get me wrong, there are significant benefits to that. If I don't have to bill a client for going and twiddling my thumbs in court for 2 hours, when I can just be on the Zoom, conduct the conference in 2 minutes, right? There are efficiencies. What gets lost is that sort of camaraderie of the bar. So I do think it's incumbent on state or city bar associations to offer continuing legal education courses on this. And it's really incumbent on attorneys to take those types of courses on areas that they don't know. It's okay to not know. I think there's so much pressure in the legal profession that you are supposed to be an expert. You're almost supposed to be like one of these chatbots where you know everything, or you can't concede a point. But if you're only taking continuing legal education in areas that you already know, how are you benefiting your clients or your practice? So the more we learn about this, the better we all are.
Correct me if I'm wrong, though. Massachusetts doesn't have mandatory MCLE, does it?
That is true. We don't have,
which is always astonishing to me.
right.
The Athens of America, Boston, there's no mandatory CLE. What about the duty of technical competence? Is that in the bar rules up there?
It's in our rules of professional conduct. So there are things that, again, you can say it's within the spirit of something, right? That you are supposed to be competent, that you are supposed to ensure that nothing you submit to the court is false or lacks any merit, that you are going to be a zealous and diligent advocate on behalf of your clients, things of that ilk. But there's no express rule in Massachusetts in the professional conduct about AI. And truthfully, I don't think there needs to be. My concern is the moment you start defining something, we always find loopholes, right? So the technology advances so much that if it's not within that definition, you use something that isn't, and then you can argue that you're fine.
Right, because it's interesting, because talking about technology competence, Florida just added generative AI language into their duty of technology competence, which to me, while some people thought that was a good thing, I thought, well, what are you going to do when the next technology comes along and the next? To me, I think if you're just establishing the duty of technology competence and being current with technology, that's over encompassing. That basically covers the gamut, and you don't have to point out specific technologies.
Right.
What I'd say we have here, at least at the state level, there was a decision that came out in February of this year. There was an attorney who got sanctioned for citing cases that don't exist, and I believe it's a wrongful death case law. And the opinion that the judge wrote in that, awarding sanctions, there were sanctions for $2,000, and said, you know, I find this to be light. And the most important, mind you, it's dicta, but still, in that said, essentially, that the defense of ignorance will wane with each passing day as people become more and more aware of these types of technology. Arguing that you don't understand how it works will not pass muster. So I'm not quoting, obviously I'm paraphrasing, but I took as you are all on notice that if you are so much as using this technology, you are responsible for its use. And so it's incumbent upon you to understand it.
Judge Fasciola used to tell the story when he was still on the bench. Well, he told the story after he left the bench about a thing that happened. But again, in the early days of e-discovery, they're having some argument, and the one side is some young attorney who's very aggressive, and he wants to do a load. They're talking about load files or something, and the attorney on the other side is more chronologically challenged and says to Judge Fasciola, Judge, I don't know, you know, I'm an old-fashioned belt and suspenders sort of guy, and fountain pen and yellow tablets. I don't understand all this new found technology. And Fasciola just goes, whoa, time out. He says, approach, you know, the words no litigator wants to hear. Approach the bench, knuckleheads. And he leans over to the guy. He says, do you realize you just committed malpractice on the record? Right. You just said on the record you didn't understand what was going on. Like, no, that's not a defense. You know, we're going to adjourn for lunch, and you're going to come back after lunch and bring somebody who does understand what's going on with this newfound stuff. But you're right. It's a gradual process, right? We're learning as we go.
It takes judges like that, right? It takes judges who also understand the technology and are expecting it to be part of a lawsuit. And that hasn't necessarily been the case. I mean, I don't think I'm speaking out of turn when I say that judges often aren't the most innovative, right? You read decisions about the internet that were published in the late 90s, early 2000s, and that it takes like 3 paragraphs for them to explain what the internet is. But most of us were like, I can sum this up in a sentence. So it's for them to understand it.
They're litigated. I mean, where do judges come from, right? They're litigators. They're from the same gene pool. So, you know, and that was great for years and years because everything was equal. But now you get these young whippersnappers coming in who maybe know a lot more about the technology, and hopefully that's winnowing out as we get younger judges. And I don't know if it is or it isn't.
Yeah, or at least think they know more about the technology, because sometimes that's the challenge and the problem. So I want to ask you a question from where we started, because you say you don't use AI. Right. But what I'm interested in is what would make you change your thinking about using it, at least for idea generation, some first pass kind of thoughts about something where you would kind of say, hey, obviously my duty is I'm responsible for the content. I have to review it. I have to make sure it's accurate, what have you. But what would be required for you to consider using AI in certain situations?
So I can give 2. Let me not answer your question like a true litigator first, and then I will answer your question.
I thought you were going to start with it depends. Or
it depends. Well, it's very fact intensive. So I do use AI in my personal life, right? Or for things about law. In fact, the very first time I remember I used ChatGPT, I had to give a talk to high school students who were interested in becoming a litigator. And I had the foggiest idea what on earth to say to these kids. And I asked ChatGPT, I said, you know, I'm giving a talk, give me 15 minutes worth of information. And within 30 seconds, it gave this information. I thought, oh my goodness, this is fantastic, right? At first blush, it's amazing, right? And then as I started to, it's the rule of entropy, right? The first time the ball bounces really high, and each time as you know a bit more, you're less impressed with the bounce. So I think that was enough to give me pause in using it in my private practice because I saw some of the issues. I'll give you an open loop, what I refer to as open loop and closed loop. Open loop meaning it's scraping everything that's publicly available. I would need to really know the data. I would really need to understand, which they'll never give me because it's proprietary, what the data sources are, right? Because I need that certainty to know that what I'm being provided is correct. You know, a lot of my job, yeah.
Well, and I don't mean to interrupt, but in some cases you can ask it questions where it will give you links to resources where it got the information. Would that be a step for you to go, okay, now I can go check out these resources, which sometimes you really need, well, actually you always need to do, because the resource doesn't always say what the AI says it says. But would that be a step in the right direction for you?
I would say if it's able to provide me sources that would provide more comfort. You know, what I like to say is, when I was coming up, if you were foolish enough to copy and paste what Wikipedia said, you deserve to get caught. But if you were
good example, good example.
Right, and you use it as a launching pad to then do your own work, that's fine. So if I would consider it for that, for the purposes of getting a start in the research I needed to do. That perhaps, but I wouldn't then rely on that. It would just be that, again, writer's block helping me there. Then I would consider it. Now, and I've seen enough times where it provides a source. Now you have to do the next step, Doug, and that's what a lot of people don't do.
Right.
It gives a link and they go, that's good enough. And they don't actually click the link.
Exactly.
Yeah.
Right. It's that overconfidence again, right? You have to actually verify what it's providing you is correct. Because as a litigator, I am affirming and representing to the court when I sign a pleading that, to the best of my knowledge, its contents are true and accurate.
Right.
And I personally take that duty very seriously. And I know that when I look my clients in the eye and I say to them, I'm going to do everything I can to help you, I mean that. And I'm not going to cut corners. So that's my personal preference. Now, if another attorney wants to do that and they're doing their due diligence, that's fine. And that's a discussion they have with their client. The other thing is, I have not yet had that conversation with a client to say, I intend to use AI and I want to make sure you're okay with it. And it is my opinion that, especially for litigation, it is important that an attorney have that hard conversation up front. Whether it's in your engagement letter or it's a conversation, make sure you have your client's consent to use AI. Because if you don't, and then you get pinged for making a mistake and your defense is I used AI, how's your client going to feel? What do you mean you were using AI? You're billing me all these hours.
Yeah.
What were you doing if you're using AI? It should have been less, right? And then you have that uncomfortable conversation of justifying your costs. So that's open loop. Closed loop, I'd say if it's one of these service providers that we talked about that are, you know, employment law, contract law, construction law, what have you, I would consider that. Again, I would need to better understand, is it going to tell me when it doesn't know? Right? There are some of these that are starting to do that. They're starting to actually say, cannot provide an answer. If I get that as a response, I feel more comfortable. Because then I know it's not just making something up to try and make me feel good.
Yeah, you know, that's a great point. And I think some of this will be baked into the products. At the conference that Doug and I were at about a month ago, there were several e-discovery vendors who were showing their new AI product, and one of them actually had it up on the screen, and I said, "Can I play with it? Can I do something?" And they said, "Sure." I said, "Can I ask a question?" And I could see the salespeople, couple of the younger salespeople are sure. And I can see the older guy who knows me trying to pull them. Like, no, don't let him touch the keyboard. So of course I went over and I typed in, "What is reality?" And I got the answer I would expect to get at, that I hoped I would get. The answer came back immediately saying, "There is no data in this database that supports your query.
Right.
Please give me another query or go back and take a look at the data to see if you can reword this somehow." But
yeah, I also would have taken the answer as 42, but you know, that's
yeah.
But
that's it.
Nicely
They
done.
build those guardrails in and say, if you can't find it, say so. Don't make something up.
Right.
That's just a question of programming authority. And I looked at them and I said, this is great. This is the first program that said that to me.
Right.
Like, okay, no, I can't answer that question, and I'm not going to try to answer that question. So yeah, I think the programs will get better at this sort of stuff. Real quickly, we talked about different programs and you talked about different platforms, but as Doug touched on it, as Microsoft particularly starts baking this stuff in, and I'm seeing Thomson and Lexus starting to bake some of this AI into their product as well. Isn't that going to make it more acceptable to us? It's going to be part of the flow. We're going to get exposed to it, or is it going to be more like, well, I didn't even realize it was there.
So to sound like a fogey, my concern with that, and it's really my concern with the use of some of these LLMs and some of these e-systems, is the significant loss of critical thinking. I do think it's going to become more prevalent. I think it's going to take a long time, especially in the litigation.
Some people would say that train's already left the station.
Well, yeah, especially for lawyers, the suggestion that any of us have critical thinking, like we chose to become lawyers. We lost that a long time ago. I'd like to think part of what helped me become a good lawyer was getting my fingernails proverbially dirty, reading the case law, understanding the situation, understanding why different situations apply in different circumstances.
Yep.
And if I'm just relying on a data set, then I'm losing that critical thinking. And I don't know, I think that's what's really key as a litigator, is being able to take the same law and apply it differently in different situations.
Oh, sure.
That's my concern with that.
Is there a level where both can be applied at the right level?
I think so. And I, it's funny, prepping for this and thinking about what you guys might ask me and what ChatGPT said you might ask me. No, I'm just kidding. I think there's a balance there. If there's rote law, right? If you know the elements of a breach of contract are, so forth, right, that's fine. You don't really necessarily need critical thinking for that. So if you're going to be able to use it for those things, fine, right? Or a document analysis where it's saying, I just identify every document that's, an email sent by this email address. Fine. That should be the foundation, right? That's where you can use AI. For the floor, what you build on that floor really needs that human element, because a case changes and it morphs. Your understanding of what's really at issue when you file that complaint or you respond, with an answer to a complaint, and where the case morphs when you go to trial 3-4 years later, it changes because of the information.
Good point.
Right.
Good point. So you need to know that information, and if you are just outsourcing it, you might not remember those things. Oh wait, I remember when I reviewed this, that was something that I flagged. Now it comes up in a completely different context.
Yeah, I'm looking at it a whole different way now. It has a different implication to me. Yeah,
right.
Yeah.
Makes sense.
No, that's a great point.
I agree more.
Well, Adam, as you could tell, Doug and I could talk about this all day, or at least I can talk about it all day.
I would be there. I'd be there with you.
So I really want to thank you for your time and your insight. This has been great. Again, I really wanted to get that perspective of what's going on with real litigators who are actually in courtrooms every day, dealing with this stuff. And it'll be interesting to come back to you in 6 months or a year and see if it has really changed. Are some of these things, has the bar risen a little bit further?
It'd be an honor if we want to do our September check-in to see where things are going. I really appreciate, eDiscovery Channel, you guys having me, and I've really enjoyed this. And
our pleasure. We'll
bringing this all to light.
And next time I'm in Boston, I'll try to give you a shout, see if you're around.
Please do.
I understand Durgan Park no longer exists, though, right?
It's not. Sadly, you go somewhere else for your roast beef now. But
in my case, from a very early age, we would drive into town. My dad would be taking me and my brother to a Red Sox game. It was swordfish steak. I was introduced to swordfish at Durgan Park, and ever for years and years afterwards. decades afterwards. If I went to Durgan, had to be a swordfish steak.
Sadly, it's not there. Cheers is still here though, so you still got that.
Okay,
Right.
I'll settle. I guess I'll settle.
Indeed.
Thanks again.
Yes, thank you, Adam.
Adam
Really
Good.
great to talk to
Let
you.
me say it again. Adam Gutbezhal
Got it.
from Ruberto, Israel, and Weiner in Boston, Massachusetts. It's been our guest today, and we really appreciate your time and effort. We'll look forward to seeing everybody again next time on the eDiscovery channel.